The Attorney General.
Thank you very much, Madam Speaker. And if I may be permitted this afternoon to make some short contributions in support of the Public Procurement and Disposal of Property Amendment and Validation Bill 2023, which seeks to amend 3 sections of the Act, the Public Procurement and Disposal of Property Act No. 1 of 2015, and to validate certain actions taken in respect of statutory instruments made pursuant to the Act. And I hope that I will be forgiven, Madam Speaker, if
Member for Naparima, now that you're coming back to your seat, please, not too much of a disturbance. Attorney General.
Thank you very much, Madam Speaker. I was in the process of saying that I hope that I will be forgiven in the few remarks that I make if I attempt to speak as a lawyer, if even I don't stand against a backdrop of law books or otherwise represent myself to be that which I'm not. I want to make some preambulatory remarks, Madam Speaker, on a couple of principles of statutory interpretation, procedure in this House, and constitutional accuracy. So if we start with correction of errors, good lawyers, Madam Speaker, will argue with fervor and correctly that what appear to be errors in legislation may not be quote-unquote corrected, and that the law must be applied meanwhile according to its literal meaning, and that corrections of perceived defects are only correctable by the legislature. The authority for that is the Privy Council and the Attorney General of Belize and Belize Telecom Limited. On the other hand, Madam Speaker, and with equal fervor, lawyers will argue that the courts, not the legislature, may be permitted to correct obvious drafting errors. The authority for that is Inco Europe and First Choice Distribution, a 2000 House of Lords decision. What is clear, Madam Speaker, is that the correction of perceived error in legislation is for judicial pronouncement or legislative enactment. And by the bill before this House today, in accordance with law, the government has opted for legislative amendment to correct an error. No one will be able to say that either on the 29th of May or on the 29th of June, the Attorney General or the Minister of Finance unlawfully arrogated onto themselves the authority to correct what we have come before this House today to correct, because it is not for persons reading the law to correct the errors. That is for the legislator, and it is why we are here today.
Madam Speaker, 4410. My learned friend is reading his speech, you know.
Attorney General, please continue.
Thank you. So that
I think we conditioned the approach today with temperance, and I expect that from both sides. Attorney General.
Thank you, Madam Speaker. I was in the process of saying, and I'll repeat myself, that because lawyers on either side accept that legislative errors are to be corrected either by the courts or by a legislature, we are here today before this legislature to correct errors in the law which was applied on its literal construction on the 29th of May and the 29th of June. And what the government did was to apply the law as it was existing on the face of the legislation at that time in order to continue with the business of government, simply. And the business of government Madam Speaker, has been spoken to very recently in a case to which I always find myself able to turn because it is, in so many different respects, a judicial pronouncement that guides many different aspects of both legal and parliamentary procedure. And that is the case of Dominic Suraj and the Attorney General of Trinidad and Tobago, 2022 UKPC, page 26 at
Members, I'm not going to tolerate this. All right? And if again I give members a guidance, if members can't tolerate what is going on, they can go outside and come back. If I have to stand on this again, I will use the authority of the chair. Attorney General.
Thank you, Madam Speaker. So I turn to that Privy Council decision and to paragraph 70 of the decision because it speaks eloquently to the proper interpretation of Section 53 of our Constitution, that is to say, Parliament's capacity to make laws for the peace, order, and good government of the country. And this is what is said, if I may, with your leave, read from that passage at paragraph 70. The framers of the 1962 Constitution and of the current Constitution intended that Parliament, operating in the usual way, rather than under the supermajority procedure, should have power to make laws for the peace, order, and good government of the state. The inference cannot be drawn that the Constitution was intended to stymie government by ordinary legislative activity. That is what we are here about today. That would undermine the power of effective government in the public interest by ordinary legislative activity which the Constitution confers on the Parliament. So I start by pointing, Madam Speaker, to the correct procedure that the government is employing here today to come to this legislature to correct the error that exists ex facie Section 7, subsection 7 of the Act, so that it may be corrected legitimately by this legislator in order to refer to the section that it was intended to refer to, subsection 6. Now, I want to speak a little bit as well, Madam Speaker, with your leave, to the well-known parliamentary procedures of subsidiary legislation, that is to say, negative and affirmative resolutions. And we only have to turn, with respect, Madam Speaker, to Section 75, subsection 7 of the Interpretation Act, which provides, and if I may read, subject to negative resolution of Parliament, shall, as soon as may be after they are made, but within the prescribed period, be laid before each House of Parliament. Where either House within the prescribed period resolves that any of these instruments or documents shall be annulled, that instrument or document is void, as from the date of the resolution, but without prejudice to the validity of anything done thereunder, or to the making of a new instrument or document. The value, Madam Speaker, of a negative resolution, which sometimes seems to escape some of us, is that a negative resolution puts the instrument before the House by laying it in the House or in the Senate, and there is a prescribed period of time by which and within which a member who thinks that that which has been done by the statutory instrument known as a negative resolution can come move the motion and call for a debate of the Parliament to annul the particular instrument. So when we come to look at the procedures that are being recommended by this amendment to substitute the term affirmative resolution for negative resolution, we are not recommending that the oversight of Parliament should be bypassed. What we are doing is recommending a procedure that will allow for the ease of doing business, that is to say, the expedited procedure of being able to accomplish that which must be accomplished today, because it has to be done today, and to lay it before the Parliament by the process of negative resolution, so that if later on a member of the Parliament wishes to raise a question as to the validity of that which has been done, that question can be raised. And that is very important to appreciate, Madam President, in the context of the amendments before this House in relation to Section 7 and in relation to Section 63 when we get there. Under Section 7, subsection 6E of the Act, the Minister may make orders to prescribe for certain circumstances. The Minister there is a member of the government, a member of the cabinet, be he elected or be she elected or nominated to the Senate and appointed on the fiat of the Honourable Prime Minister. This is a responsible member of the government to whom the presumption of regularity applies necessarily. And there is a very interesting statement that was made many years ago by Justice of Appeal Clinton Bernard, who went on to become Chief Justice Clinton Bernard, that I would like to read into the record of this House. It is a statement, a judicial statement from the case of Attorney General and Casey Confectionery Limited, reported at 1985, 34 West Indian Reports, 387, at pages 415 to 416. And with your leave, Madam President, Madam Speaker, I will read the dictum of Mr. Justice of Appeal Bernard. He says this: I would like to turn to the question relating to the presumption of regularity in the acts of public officials which did not find favor with the trial judge. He refers to Attorney General Lopino Limestone, in which he says, I made the reservation referred to in the main judgment in support of my stand that the presumption is part of the law of this republic. And in order to show that it is well-founded, I refer to a number of decisions in other jurisdictions. The presumption is a salutary and sensible concept of government action. It is, in my view, essential to our democratic system of government that confidence and trust must prima facie be reposed in public officials and more particularly senior ones. It has never been considered to be morally right that one should condemn the whole for the misdeeds of a few, hence a presumption of regularity in their acts for which I contend. Public officials, as the term connotes, are people who render public service. And what they do can only be set aside, and Mr. Justice of Appeal Bernard continues, by proof of mala fides on a balance of probability, so long as it can be demonstrated by evidence that the act of the public official or organ was a hostile act or an intentional and irresponsible act, that in my view will be enough to rebut the presumption of regularity and to infer mala fides. The relevance of that statement of the law of this country in relation to an act of a minister made by ministerial order pursuant to Section 7(6)(e) of the Act as it currently exists, and the relevance to saying by the amendment that is being proposed that such a ministerial order, either done on the recommendation of the Office of Public Procurement or done by the minister in his own discretion, is that that ministerial order, it is being proposed by the amendments that we move for today, Section 7 and Section 63, will be laid before the Parliament by way of negative resolution procedure. So if any member of the Parliament looks at what the minister purports to do validly under Section 76E or under Section 63 and is able to raise a case to annul that which has been done because it has been done irregularly or by act of malefides, Parliament continues to have oversight by that negative resolution procedure, and there is nothing wrong with that. I turn next, Madam Speaker, to a discussion that I am saddened to listen to and I am saddened to read about when the other side allow themselves to speak to acts or other functions of the judiciary. Because one of the ministerial orders that we are here today asking this House to affirm is a ministerial order which has effectively, and this is I speak to Ministerial Order number 164 of 2023, which has put into effect different services and orders made by the minister pursuant to Section 7(6), subsection E. There was an interesting exchange that took place many years ago, Madam Speaker, when the then government, which is now in opposition, attempted to control the judiciary. The Chief Justice at the time wanted to go off on a judicial visit, and the Attorney General of the day claimed that as a result of being made responsible for the administration of justice under the Constitution, legal affairs, he could control the purse strings of the judiciary's allowances to go off on legitimate business. And that led to the appointment of a commission of inquiry in the person of Mr. Justice Telford Georges, one of our most respected judges who has ever graced the bench not only of Trinidad and Tobago, but throughout the Commonwealth and indeed in Africa. The Telford Georges report was commissioned by the then Law Association on the 3rd of, if I'm not mistaken, I'll get the date correct, 3rd of November, 1999. And in that report, in that special resolution of the Law Association, Mr. Justice Georges was asked to, among other things, look at the relationship between the judiciary and the Office of Attorney General. And it is very instructive, Madam Speaker, that and I beg your leave to read very briefly from two aspects of the judgment of the report of Mr. Justice Telford Georges, which was delivered on the 16th of February 2000. At page 13, he says, historically, the Attorney General has been the member of Cabinet responsible for bringing to the attention of Cabinet matters of concern to the judiciary. This is an inheritance from the pre-independence administrative structure. And then at page 20, in examining how in the year 2000, and indeed as it continues today, I add, Mr. Justice Telford Georges tells us that in examining the role and function of the Attorney General in relation to the judiciary, he says at the end of paragraph, page 20, I have spoken to two recent holders of the office of the Attorney General, Mr. Keith Sobian and Mr. Russell Martineau, Senior Counsel. Both were clear on the fact that as Attorneys General, They're considered their roles to be that of conduits between the judiciary and the executive. And that role of conduit does not offend. I've moved on from the quotation. That role of conduit does not offend the concept, the constitutional concept of the separation of powers, because it is entirely permissible for the judiciary to communicate with the executive through the conduit that is afforded by the constitutional function of the Office of Attorney General, which has existed before independence, which we inherited in 1962, and we have continued to subscribe to under the present 1976 Republican Constitution. I say all of that to make the point, Madam Speaker, that when we look at the instrument 164, which we are asking this House today to affirm, and we look at the severalty of goods and services which are set out in there, that has to be understood as a consequence of a communication made to the executive in the person of the Minister of Finance through the Office of Attorney General on behalf of the judiciary to deal with all of the matters that are set out in that particular legal notice. The management of court processes, Madam Speaker, involves a number of instances in which the judiciary must be able immediately and often without notice to deal with matters that come before either the judiciary in its judicial capacity or the judiciary in its administrative and other capacities. In the judicial capacity, an example comes to mind, the Fuji warrant or the arrest of ships. Injunctions, those are matters in which courts have to deal immediately and without notice on many occasions with the reality of having to take immediate action. And equally, it applies to the management and administrative staff in arrangements that have to be made, for instance, in transporting domestic violence victims, or securing of vulnerable witnesses, or transporting of jurors. It does not always have to do with the sequestering of a jury. That in itself is a discipline and an activity that needs to be dealt with in a very strict way. But even when a jury is not sequestered, a report can reach to the judge by a message sent to the registrar from a juror that that juror has got word that somebody is interfering with that juror's child. Witness tampering, all of these are examples. Are we really saying that in those circumstances, the trial must stop and the management of the judiciary must go through this Regulation 14 that the leader of the opposition just pointed to and go through the 30-day standstill period, notice period, and the standstill period in order to be able to direct the registrar to get a security guard immediately to go to the home of that juror whose child is being threatened? It's just not realistic. And we must be careful, and I say this for the benefit of the listening public, we must be careful when we come to this house not to cheapen the process of this house by cheap politicking. A marshal takes an oath, Madam Speaker. The oath is to keep a jury safe and fed and watered. And at every stage, while that juror is sitting in court, that juror has to be administered to so that he or she may concentrate on the task at hand on any given day, whether she is sequestered or not, with the purpose and singularity of mind to concentrate on the evidence that is before the court that he or she is being asked to listen to and to assimilate. And they must do so with the confidence that their families are protected, that their properties are protected, that they are not vulnerable to tampering and threats and insecurity. And that is why, if we did not make provision for this particular legal notice, we are in effect undermining the very independence of the judiciary. There are very many examples in which the judge and the administration of justice must be able to act in a random way, because today Taxi X may have been recruited, procured to transport the jurors, and the juror gets into the car to go from Diego Martin to Port of Spain and sees a picture of his or her child on the seat with an X over the face. Immediately that taxi has to be cancelled and another taxi service has to be procured immediately, because the juror must be confident in knowing that the judiciary's capacity can protect him or her and their families. That is why you need the nature and quality of the legal notice that is before this House by way of legal notice number 164. And there is nothing sinister about that. Madam Speaker, I could go on about any number of other justifications for the several matters that are laid out in legal notice number 164, but I think I've made my point. The bill before this House, Madam Speaker, and I've already spoken to it, seeks to make one amendment to change subsection 7's reference to subsection.
AG, you have 3 more minutes of ordinary speaking time. You're entitled to 15 more minutes to wind up.
I would wish that time to wind up. Thank you.
Please proceed.
And I've already spoken to that in terms of the negative resolution, and I will not overdo my limited time that is left, Madam Speaker. The point there being that both with respect to Section 7 and with respect to Section 63, we are speaking about allowing the Minister of Finance by this amendment under the powers given to him in Section 76E and in Section 63 to be able to make orders, ministerial orders, exercising his authority or her authority as minister, relying on the presumption of regularity, that what is being done in the interest of peace, order, and good government of this country, so that we can continue tomorrow to continue to do business for the ease of doing business. I read the excerpts from Hansard, my very good and learned friend, Senator Thompson Ahi, in 2000, when she made submissions in the other place with respect to the affirmative resolution, 2020. But I am certain that on reflection, we can understand now, given that the process of a negative resolution allows for the ease of doing business while retaining parliamentary oversight, that the good senator will be able to accept that now that we have seen the act in operation, because it was proclaimed in April of this year, we need to do the necessary adjustments to be able to allow this country to continue to function, as opposed to being brought to this standstill which we have been witnessing over the past several months. And there is no fear, and there is no cloud, and there is no doubt that the process of the negative resolution will allow that which we are all anxious to ensure, and that is, having put the act into operation, we continue to have the recourse to the fallback of parliamentary oversight by the negative resolution process, which allows for expedition subject to annulment but not for the convoluted passage of having to come to the House of Representatives and be debated, and having to go to the Senate and be debated before we can take any expeditious action. So that I am fairly confident when we get to that stage, Madam Speaker, that we will reflect on the operational value of the presumption of regularity, the House procedure of a negative resolution, and recognize that in the interest of the ease of doing business, we can proceed confidently, given the fact that we have so many precedents. We have any number of pieces of legislation in this country that employ the device of the negative resolution. The Insurance Act, the Trinidad and Tobago Revenue Authority Act, the Gambling, Gaming and Betting Control Act, the Trinidad and Tobago Special Economic Zones Act. All of those are pieces of legislation which employ the process of negative resolution. The country continues to function and we are moving on. Clause 4 of the bill, Madam Speaker, seeks to amend Section 58 by introducing a new Section 58A. Subject to regulations made under Section 63, the procurement of goods and services up to $1 million are exempt from the procurement requirements under the Act. Well, I say only two things on that. And the first that I say is that the Minister of Finance, Honourable Member for Digger Martin, Northeast, has spoken eloquently already to the examples across the Commonwealth and across the world of the fact of the threshold being an acceptable process by which we are going to amend this legislation to allow for the ease of doing business. Subject to, and this is my second point, subject to the oversight either on the recommendation of the Office of Procurement Regulator or in relation to Section 63, which we are seeking to amend, in his own discretion, but always subject to the negative resolution process, which allows for parliamentary oversight. What is wrong with that? Nothing. We must stop scaremongering for cheap political gain. And I turn to Section 63(1). The minister may, the amendment is in his own discretion or on the recommendation of the office make regulations, etc. And very importantly, the procedures for the procurement of goods and services up to $1 million under Section 58A. So this is not, and I say regrettably, this is not, as the Guardian editorial today is suggesting, a repeal of the entirety of the Act. This is to carve out a limited operational window of opportunity so that business can continue subject to oversight of Parliament in order that the business of the country can continue and people can continue to get work. That is something that we are overlooking. And the amendment we propose at Section 63(3) is that regulations made under this section shall be subject to, cross the word affirmative, negative resolution of Parliament. What is wrong with that? It remains subject to the oversight of the Parliament. So, Madam President, Madam Speaker, with respect, and I beg your pardon, nothing about this bill before this House today is in the least irregular or sinister. It is coming to this House to recognize, as we are beginning to operationalize the Act, we recognize that we must now begin to tweak the process to allow the country to move forward and to permit this government in its constitutional discharge of its duty to govern according to peace, good order, to govern the country in the interest of the citizens of this country. And that brings me lastly, Madam Speaker, in my time, my limited time, to Clause 6, the validation section. All statutory instruments, including Legal Notice number 206 of 2023 and Legal Notice number 164 of 2033, purported to have been made under Section 7 of the Act, and all acts or contracts done and things purported to be done pursuant to those instruments are deemed to be lawfully and validly made and done to the extent that they would have been lawfully and validly made and done had the instruments complied with the requirements of Section 7.7. Well, that validation process is the very process that under the Interpretation Act we already use, and in this House we use for the process of negative resolutions. Even when the negative resolution succeeds on a motion to annul, that which has preceded the date of the annulment is deemed valid. We are saying today in this House, we ask this House to approve the fact that the two instruments, 163 and 203, were made under a section which we are asking this House to correct today for the correct reference, and we are asking that they now be affirmed in accordance with the further amendment by way of negative resolution. And there is every good reason why, with respect to what has occurred in relation to the foreign visiting heads of government and other dignitaries, and to the services that have been afforded to the judiciary, that we should validate all of that. The idea, the suggestion that, well, the court comes to a close at the end of July, and why, therefore, 3 months into the end of August. Those of us who practice in the courts know, and I say this with the greatest of respect to the opposition leader who at one point practiced law and should better inform herself. The vacation court continues to sit. Emergency services continue to be afforded by the courts. So what is this fiction of saying, why extend it for 3 months when we know the courts are coming to a close at the end of July? It is unacceptable that we should come to this House, speak to the public, citizens of this country who expect better of us, and use such cheap politicking to score points. I deplore it. And I say this deliberately here today. As a member of the inner bar, I deplore it, but by those of us who should know better. And so, Madam Speaker, without having to dwell unnecessarily on the very many things that have otherwise been said, I say to this House, this government is before the House today to correct an error on the face of the legislation, to introduce a threshold, an operating threshold to allow the country to function under the continuing oversight of the Parliament, and in order that the government can discharge its constitutional mandate pursuant to Section 53 of the Constitution. And I say with the greatest of respect that the arguments that have been put, and I have no doubt the member for Diego Martin Northeast will deal with it in his wind-up, to suggest that recourse could have been had to the regulation for methods and procedures, regulations 4, 12, 13, and 14, could have been used instead of the ministerial orders that were promulgated on the 29th of May and the 29th of June. That is, it's misleading. There are procedures in there that do not make those regulations available in the time frame that they had to be introduced. And the member, the leader of the opposition, knows that. She is misleading the public once again, with the greatest of respect. But I'm not going to take the thunder out of the mover of this bill, who is going to wind up when he speaks
Madam
to it.
Speaker, I rise on Standing Order 48-6.
Please proceed.
Thank you very much, Madam Speaker. And I say, lastly,
Member for St. Augustine, I heard that. Could you just withdraw those words?
I withdraw.
and I say, lastly, Madam Speaker, that we must get about the business of governing this country in the interests of the people of this country in a way and in a manner that does justice to and serves the people with the dignity that they deserve. And with those few words, Madam Speaker, I am happy to accept. Thank you.
Thank you very much, Madam Speaker.